Welcome to Inheritance Solutions for a Diverse Community with Richard Hall. Join us as we delve into strategies and insights that ensure your legacy is secure and your loved ones are cared for.
Hello and welcome to Inheritance Solutions for a Diverse Community with Richard Hall, founder of Bottom Line Lawyers. Richard combines extensive legal and real estate expertise to help clients with estate planning and to protect their families' futures. I am your host, Kevin Rosenquist, and today's episode is going to be all about wills versus living wills, the crucial role of an attorney in estate planning. Richard, so good to see you again.
Great. Good to see you, Kevin. Thank you.
So can you start by just explaining the key differences between a will and a living will?
Yeah, that's a great question because people frequently confuse what a living will is. So a will is a document that takes effect upon your death, and it says what you want to have happen with your belongings, your assets, as it were. A living will, on the other hand, is an instruction to take effect while you're still alive, but if you're not competent to make legal decisions on your own behalf. It generally focuses on healthcare decisions, when somebody should pull the plug or not pull the plug, all the related healthcare issues that you wouldn't be able to make for yourself if you were, in fact, lacking legal competence. The two are absolutely essential documents.
So it's an important note is that you would believe people should have both, is what you're saying.
Yeah. Absolutely. People have to have both because for most people, it's more important what happens to them while they're still alive than after they're gone. And particularly when it comes to healthcare, and one of the key aspects of that is making sure that whoever you designate as your agent really understands what it is that you want to have happen.
Yeah, good point. Good point. And what are some of the common misconceptions that you run across that people have about wills?
One of the most common ones is that a will can suffice in lieu of a trust. And although that is occasionally true, for the most part, it isn't true. And it's not true for a couple of reasons. One of those reasons is that property that's held in a trust benefits from what's called a stepped up basis at the time of decedent's passing, and a will doesn't afford that. Another benefit of and I'm sorry, kind of veering off track here, there aren't that many occasions when a will alone is the correct tool for the process. There are a few. In California, for instance, you have what's called a small estate affidavit. So if you have property that overall, as long as it's not real estate, is worth less than about $190,000, it can go through a separate process. California, though, just revised the law that allegedly made it simpler, but you still have to go to probate court in order to process a small estate affidavit. So there's still hoops to jump through. It's a longer process and a more complicated and frankly, a more expensive process. The living will, though, is what you want to have when you're going to go in the hospital, when you really need to have it in place at any point in time. But that will is, in my opinion, living will is a misnomer. It doesn't really express what it is. Other people call that an advanced healthcare directive, other names as well for that. And I think that's a more apt title. And if you think of a living will as taking care of stuff, the reason it's called living, it takes care of things while you're alive. And the will takes care of things when you're dead. And that is the most essential distinction. But you need to have both because nobody knows, am I going to get sick, put into a medically induced coma tomorrow? Do I have an automobile accident or whatever that puts me in that situation? And so you need something in place to cover that potentiality so that it's not a doctor making up their mind about what you should have happen. It's you or the person you've designated making up the mind about what should happen.
Is there a certain point in someone's life where you think they should get a will? Is that something you think someone should get when they turn 18, or should they wait until they acquire some assets? Like, what is your kind of take on that?
It's funny you'd say that. I was about to say when they turn 18.
Really? Yeah.
Because before you're 18, then it's your parents, assuming they're alive, it's your parents' decision about what happens with you. But at age 18, somebody goes in the military and they come back with a permanent disability and they need to be treated. Maybe while they're in treatment, they can't make a decision for themselves. They have an automobile accident. Somebody has substance abuse and they are no longer legally competent to make their own decisions. Well, then a living will takes care of that. And a will in general will take care of any assets you have. I mean, generally speaking, yes, people acquire more assets as they get older. On the other hand, I had a client just recently who was, I think he was 19, and he was making $40,000 a month. He needed a will and a
I
trust.
got to get into whatever he's doing.
and what he was doing was a lot of fun too. So yeah,
Good for him.
That's what I said. Oh, how do I start this process?
Yeah, right.
But my point is, you just don't know when the need is going to specifically arise.
Right.
So, I was a Boy Scout. Be prepared, right? That's all. Though that was live long and prosper.
Yeah. I mean, that's. I don't think that's Boy Scouts, but who knows?
Yeah. No, the Boy Scout one is this one. Live long and prosper is this one. Yeah.
All right. Star Trek and Boy Scouts. We got it.
Yeah. So you just don't know when that's going to happen to you. So you need to be prepared in that regard. The other thing is that a will is not just about your things. It also specifies, for instance, if you have children and mom and dad die in a car crash, who takes care of the kids? If you don't specify that, the court's going to decide that. And when the court decides, they're going to say, well, next of kin, which you may not want at all. You may say, these are not the people I want raising my kids. They don't share my values or anything else. And so in that will, you specify who's to fill that role. And there's a myriad of other provisions that can be put into a will to protect your children, protect your assets, et cetera. But I want to also mention that at least in California, now the only state in the union, but in California, we recognize what's called a holographic will. I don't really recommend them, but it's a good stopgap. I've actually had people come in that wanted to have a full estate plan, but they had nothing in place and they were concerned about their current health condition. I had to make up a holographic will. And then I keep that will on hand. If something should happen to them, it's available. And for anybody who's listening, if they send me a request, I can send them a template for how you put together a holographic will. It's very specific requirements in the state of California, but it's effective. So it's a really good idea.
I don't even know what that is. What is a holographic will?
Holographic will is just a handwritten will. Yeah, holographic means you've written it, right? Certain things need to be on it. It needs to be on a plain piece of paper. It needs to be signed and dated. It needs to say that you're a sound-minded body and you hereby, or at least sound mind, and you hereby will and bequeath, blah, blah, blah. And that's where you set forth the things you want to do. And like I say, on that template that I've got for that I can send to somebody, it specifies all the elements that need to be present for that to be an enforceable will. And it's again, it's not an end in itself, but it's a great interim step if you're completely naked at the moment.
Is there a general time frame that you suggest people revisit or update their will? Does it depend on their lives, what's going on in their lives? What do you generally tell people?
Yeah, so I'm going to characterize this as a estate plan, whether it's a will, a trust, whatever it may be. And you should generally revise it or at least review it at least every 3 to 5 years. And whenever there's a major life event, a marriage, a divorce, a death, a birth, all those sorts of things trigger the need to review what your plans are because they change based on those life circumstances. It could be even as simple as a job change, that now you've got life insurance in your job that you didn't have before, and you want to make sure that that gets handled properly as well. You may have a retirement plan now that you didn't have before, and you need to make sure that that gets handled properly as well. So all those are components that get considered when an estate plan is drafted, whether or not we're looking at what I would consider a complete estate plan with a poorer will and a trust and power of attorney for health, power of attorney for finance, and HIPAA. Those are the 5 components that I generally put into a regular estate plan. But even if you're only doing a will and a power of attorney, which I recommend that everybody has, at least that, then those are things that get taken into account when we do those major life events.
Can you sort of unpack the living will just a little bit more? Like how does it help individuals ensure their medical and end of life wishes are honored? Like what's included in it and how does it get implemented?
Yeah, that's a great question, Kevin, because first of all, it has to be communicated. It's great to have it written down, but if you don't communicate it to the medical professionals and the hospitals that you're working with, it's not worth anything, right? And you need to be very clear with the person you assign the role of agent. It's called in a power of attorney for healthcare or living will, it's called an agent. And you have to be clear with them about what your desires are. So perhaps I can give you one example about that, and then we can talk some more about that. I had a family member who had named me as the contact person with respect to their living will. They went into the hospital they fell, they went into a coma, and the hospital called me and said, well, do we resuscitate? I said, of course, she just fell and hurt herself. We're not going to let her die for that.
Yeah.
Right?
Yeah.
And so it was not clear to the hospital, the doctor, what course of action they should take. So you need to communicate that. And it's really not only while you're alive, but your end of life decisions get specified there as well. Do you want to be cremated? Do you want to be buried? Do you want your ashes to go to the ocean? Do you want to be dropped in the mountains, even if it's not legal? What do you want to have happen, right? At what point do you want somebody to pull the plug? And that is the hardest question for most people. Nobody wants to think about their own demise.
Sure.
But, I asked folks to think of a few questions. If you were comatose and you couldn't know who was talking to you or anything else, do you care to be alive? Is that something you want? And some people answer, yeah, I want to stay alive to the absolute bitter end. When Mother Nature or God takes me, that's fine. But until then, keep me alive. And have other folks who make different choices. My best friend in the entire world last summer had to make that choice for himself. And he did. He literally had them take him off of all medication, and then he passed because he didn't want to be alive in the condition that he was in.
Yeah.
And I know many people that have had that experience. So back to your question, it's really important that be communicated both to healthcare professionals and to whoever you have as an agent, and preferably to family members. One note on that, especially with respect to the aspect of deciding whether or not life support should be terminated. I always recommend that you put that role on the backs of two people or all your family, and not one, because you really don't want any one person to say to the other one, you killed Dad. That's a heavy, heavy burden. Yeah. So important to communicate, and just so many things to think about in the context of that.
Yeah. I mean, to your point too, you're making these decisions in advance to help other people too, because who wants to decide that? No one wants to decide whether they should pull the plug on someone. But if they have a directive saying, hey, if I'm in this particular situation, I want to be out, so you just honor their wishes, it kind of takes some of that guilt and burden off of you.
Absolutely.
You're doing it for other people, really.
Yeah. And it's very much like a will or a trust, which I call an instruction book. Mm-hmm. This is a book of instruction that tells you what I want you to do, whether it's with respect to a will, a trust, or a living will, power of attorney for healthcare purposes. This is what I'm instructing you to do. And that means you're in charge of your situation and not someone else. That's really the most compelling reason for that. Most people don't want to turn that decision-making process over to somebody else. So spell it out. Tell them what you want.
I've told my wife that I want a Viking funeral. I want to be put on some sort of wooden raft and sent out into the water and lit on fire, preferably with an arrow.
You're going to have a helmet and everything?
Sure. If I put that in my will, can I make her do it? Because she told me no.
It's actually not her choice. But compelling her to do it could be difficult because you won't be there to do so, right?
That's true.
Yeah, nominate a third party to
okay, I got to find someone who's on my side.
Exactly.
So someone happens, to pass away without a will. What happens after they die? I know it goes to probate, but how does that process sort of unfold?
Yeah, it's kind of interesting because there's really three levels. You die with no will or trust. You die with only a will. You die with a trust. If you die with no provision, that is no will, no estate plan, no trust, then you are dying what is called intestate. And then it reverts to whatever the laws of the state are regarding intestacy. In California, laws of intestacy would say if you die, then your assets go split between your spouse, if you have one, and your children, if you have any. If you don't have a spouse, then they go to your children. If you have no children, then they go to your parents. If you don't have parents or they're not alive anymore, then it goes to your siblings. And there's a few steps beyond that, but that's what covers it for most people.
Yeah.
And, sometimes we will work to invalidate a will that looks like it was perhaps under undue influence that it was executed. And where we see that is with more senior clients or their heirs who come in and say, Dad had a fling with so-and-so when he got to be 80, and she persuaded him to leave everything to her, and we disagree. Well, there's 2 points on that. Number one is it is Dad's stuff until it's not. And so he is able to do that. But if that will was created out of undue influence on the part of the paramour, then it can be invalidated. And then if it's invalidated, things will pass by intestacy. Guess who it's going to go to? Not going to the paramour, it's gone to the children. There are multiple ways to examine every state situation. And, part of the reason that our podcast is about inheritance is because there's so many different issues that arise in the context of inheritance. And what our job is to take a look at all those facts, analyze them, and say, okay, what's in the best interest of my client with respect to that?
Wow. So in that situation, that's an interesting scenario. So is it hard to prove that there was undue influence, that the person was being influenced by somebody else to change their will?
It is. It's not for the faint of heart, but there are a multitude of factors to consider. When did that person come into their life? In the year before they died, and said, oh, they came and they took care of them for the last year. Therefore, they are entitled to everything that person ever owned. There's almost a presumption that there's undue influence in that. And part of the question is, what was the mental competence of the person at the time they made that choice? So if they were taking care of them, that usually implies that there was some kind of medical issue going on. Some kind of medical issue generally implies that there was some kind of pharmaceuticals involved. Okay. Can pharmaceuticals affect how someone thinks? They absolutely can. And so if we can demonstrate that, then that's a good way to counter the suggestion that everything has been given way to the paramour, for instance. That runs in both directions. I've had clients come in and it was the kids who came in and said, well, the sister has been living with dad and taking care of him in his final years. And dad gave them a 50% share of the trust and only gave the three of us the other 50%. That's up to dad. He can do that, right?
Like you said, it's dad's stuff until
it's not.
Till it's not. Yeah. Good way to look at it.
Yeah.
All right. Well, thanks for listening to Inheritance Solutions for a Diverse Community with Richard Hall. For more information, you can find Richard on social media, and you can also visit bottomlinelawyers.com. And also, please like and subscribe to our channel. We love having you be a part of our community. Richard, thanks so much for being here. Really enjoyed the conversation.
Thanks, Kevin. We'll see you again soon.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.